Happy holiday weekend, everybody, and welcome to our next webinar. We're going to be discussing why and how the USCIS is transitioning to electronic payments. This is going to be very important for you guys to understand as we get through the extensions and the transfers for most of you, but really before we get into the late January, early February filing season. So this will be a kind of an important webinar that when you receive the webinar, go ahead and save it so that you can just watch it again as we give you detailed instructions about how to pay the filing fees on our applications. As we told you, on October 28th, USCIS announced a major change to the payments of applications, primarily to an electronic payment system with very, very, very few exceptions. And this announcement follows basically the executive order that President Trump executed in March, which required modernization of payments to the federal government. Now, effective August 29th of 2025, what you were able to do is submit a additional form called the G1650, which allows for ACH transactions directly from bank accounts. We've historically, or at least the last 4 years, have been able to pay filing fees via the 1450, which is via credit card. But this added an additional opt-in to authorize basically a deduction from a operations account from a business or an individual's checking or savings account. Now, USCIS has now announced that they are no longer accepting paper-based checks or money orders for any benefits requested via the mail. So as most of you are aware, since we've represented most of you since 2007, we give you all very detailed instructions about how to identify the cost associated with the benefit that you're applying for. And then we give you very specific instructions about how to write the checks out. And those checks were made out to US Department of Homeland Security. And then we would follow the fee schedule, which keeps changing, in order for you to be able to issue checks for the payments of those benefits. Many of you are either using H1s or H2s. Some of you are using Ls and Es. Some of you are using TNs. There are different filing fees associated with each of those filings, separate and apart than just the base fee for the filing. So, for example, if you're filing an H2A application, not only are you required to pay the fee associated with the application itself, but you're also required to pay an asylum fee. If you instead are applying for an H2B, those filing fees not only include the asylum fee and the application fee, but also a fraud security fee that you're also paying for. If we were going to add premium processing, which provides that the government, if they accept your payment, is compelled to provide a response to the filing of that application within 15 business days, that too is a separate filing fee. So as most of you are aware, we're generally requesting somewhere in the area of 3 to 4 separate payment checks for our applications. That is now no longer the case. They won't accept checks themselves. So we will give you an election to either use the automated checking withdraw, the ACH transaction authorization, or a credit card payment transaction. And we will ask you to execute 3 or 4 separate of those forms in order to authorize the government to either charge a credit card or deduct from a checking or an operations account. So it gets a little bit more complicated, and we'll talk about a best practice in a little bit, but that's what this is doing. Now, many people will ask why. Why is the government doing this? Is it really an effective way of modernizing what is the most archaic agency that the federal government operates? As most of you are aware, I also litigate cases in federal and state court. I've been doing so for a long, long time. Many of you have actually joined us in class actions, which resulted in the modernization of the Department of Labor. It allowed for registration of our companies so that we can compel them to issue notices of acceptance on an expedited basis because we have historically established temporary need. We're also suing them on behalf of clients who have been wrongfully debarred. All of those filings, including the payment fees, are online. The only agency that the government operates that requires paper now is USCIS. So again, why? The reason is very, very simple. Most immigrants who are currently present in the United States can neither access credit nor open a bank account. Most immigrants operate on a cash basis. And so what the government is doing is making it a lot more difficult for immigrants to pay for benefits that they're applying for. Now, what this has resulted in is basically a lawyer or a law firm turning into a bank on behalf of their clients. We have a very strong, as most of you are aware, general rule that we will not accept checks for filing fees, that we will compel you to pay directly. And that's just because we don't want to get in the banking business. But a lot of removal defense attorneys are now having to get into the banking business, accept cash from their clients, because they're the only ones that have the access to either an operating account or a credit card. And so that's why the government is doing this. And what we're seeing in practice, because obviously I still belong to the American Immigration Lawyers Association, which is about 14,000 immigration attorneys throughout the United States, the government is serially rejecting applications based upon the submission of the ACH authorization because banks are not accepting the ACH requests from the government. And so that's why if you choose to submit a 1650, we're also going to instruct you to notify your bank that the federal government may be pulling from that account because you are opting to participate in an application for an immigration benefit on behalf of your employees. So this further complicates everything, and the government wants to do this to make it difficult. We're going to try and make it as easy as possible on you, but just recognize that that's where the public policy is headed. The public policy is headed in a direction to make the application for immigrant benefits much more difficult than it has been historically. So from now on, all payments must be from either a USA bank or payable in US dollars. USCIS will not accept payments from a foreign bank, including an ACH, card payments, or paper-based payments any longer. So they're making it exceedingly difficult for employers to apply for benefits, which is why we ask for your patience. There has been historically a way that the government has worked, and that's because USCIS, the S in USCIS is service. USCIS for the longest time, since back in the 50s, believes that they are providing a service, and that service is based upon a fee payment, which is why USCIS didn't shut down during the budget crisis that we just came out of. USCIS accepts a payment and then processes that payment because they are providing a service. We are now moving away from that. They are no longer providing services. We're essentially asking for permission to do something that's authorized by law. So they're making it more difficult. So what I'm asking for is for you guys to follow our best practices. We're going to send you very detailed email instructions. It is very onerous, and I concede that, and I apologize for that. But what we are basically doing is we are trying to get in front of a situation where USCIS rejects the application for the benefit because you have not followed the request for permission to this administration. So we are seeing a very significant shift from the provision of services for immigrants to a situation where we're essentially requesting forgiveness for participating in a program that's authorized by law. It doesn't matter what kind of political spectrum you fall within. Recognize that an agency that's supposed to be providing you a service is no longer providing you the kind of service that you are used to or that you've grown accustomed to. Again, one of the things that I always remind you is you guys are very strong political actors within your communities. You are running businesses that not only benefit your customers, but also benefit your employees. As constituency, you guys should get used to expressing your concern about how the government does its job. So every time you get asked for money from a congressman, from a senator, from somebody associated with the federal government, take that opportunity to remind them that because you participate in these services and because the government is making it more onerous for you to participate in something that they've provided historically, maybe we should consider even further modernization. And one of those possibilities is in allowing automatic payment online. And that way, you guys will get immediate receipt when the payment associated with your application for a benefit is charged to that account or charged against your operating account. It is okay for the government to move away from a paper-based payment system. What is not okay is for us to have to continue to fill out paper to commit to an electronic process that could be easily remedied online. So it's just something to kind of consider whenever you're asked for political funds, just to remind your representative that this could be fixed relatively easy. One of the reasons why I want you to take particular notice to the instructions of the 1650 is because it gives you codes that the government uses to ping your bank account. And unless you authorize the bank to withdraw funds associated with those codes, they may reject the payment. And so, yes, this is a pain in the butt, but you're also going to have to contact your bank representative and let them know that because we participate in the immigration system, the federal government may be pulling fees out of your operating account, and that's authorized. So we are seeing situations where the government is rejecting those applications and are referring to the fact that a bank has denied the withdrawal of the funds because you didn't authorize the government to ping that bank account. So please be aware of those instructions as well. Best practices. The government still requires wet ink signatures. Yes, I said that again. They will not accept electronic signatures. I can buy a house and sign all of the documents associated with my house electronically. I can buy a car and electronically execute all of those documents. I can be involved in a lawsuit where I have to execute a judgment and the government authorizes us to electronically sign those documents. I actually sent an LCA for an H-1B transfer to a client this morning who said, hey, can I put an electronic signature on the LCA because I'm out of town for Thanksgiving? And I said, no, unfortunately, we need a scan of that wet signature. So what we're trying to do is fool the government into thinking that it's received a wet signature. And the only way to do that is to have a very legible scan of a properly executed document that is in a different ink. So we're always going to ask you to sign in blue and then scan those documents to us for us to be able to submit them. I know this was a lot, and I apologize for this. It was relatively routine for us to make a request to your accounts payables department to issue 4 filing fee checks and to get those delivered within the next day because FedEx was able to deliver us the filing fee checks so we could submit your application. We're just going to add one more thing to that process, and that is you need to elect whether or not you're going to authorize us to use a credit card or an ACH transaction in order to pay the filing fees associated with your USCIS application. If you are going to use a ACH, please notify your bank that the federal government may be pulling funds and they are authorized to do that. We are going to ask you for those filing fees, but that you execute them in blue ink that's completely legible and scan those over. We may be picky. There may be times that you may scan us something that you believe is completely legible and is obviously a wet signature. And we may make the decision to ask you to do it again, not because we're being a pain in the butt, but because we recognize the government could reject your application. And this is the worst possible thing during a rush for a cap-based benefit. We don't have to worry about it in the H-1B space because they created the lottery. But we do have to worry about it in the H-2B space because the lottery that has been created does not coincide with whether or not you're going to get in under the cap. So what this means is when we get to the notice of acceptance on your H-2B application and we know the government is going to issue a labor certification, we're going to ask you for that filing fee authorization right away. Now, the benefit is you don't have to FedEx it to us. You just have to scan it to us. So we save a day. But the bad news is if they reject the application because of the execution of the 1650 or the 1450, we miss out on the cap. So that's why this is really important for us to have. So this is going to be a recordable webinar that I hope that you save as fairly important, just so you understand this. And again, we would remind you all, you're political actors. The government is no longer providing the services that you're used to or you're accustomed to. Remind your congressional representatives that there's a better way to do it. And with that, I wish you guys all a happy Thanksgiving, and we will talk again soon.